it's a lot of responsibility to, here you are. I'm not a lawyer. I'm learning this stuff out of a book. And if I don't cross this I or dot this I or cross this T right, this guy could be executed. And that was scary. But it made me good at what I do. I'm Joe Giarratano, and I'm glad that you invited me to come give this talk. I got involved with the ABA back in the 80s with Eric Friedman in the Gerarratano versus Murray case. Gerarratano versus Murray came about because of Earl Washington. At that time in Virginia, we had 38 people on death row, the majority of them without counsel. We couldn't recruit attorneys. We were trying to recruit attorneys. Couldn't get attorneys to take the cases. I was stuck filing stays for execution, habeas corpus petitions, cert petitions, and filling in the gap for the attorneys. I came up with the theory of a right to counsel under the First Amendment, fleshed it out, and filed the case in federal district court with me as a straw man plaintiff. Earl was mentally challenged, couldn't read or write. Filed the case pro se because we couldn't get an attorney to take the case. And I filed it, made myself a plaintiff so I could respond to the pleadings. I knew I had a judge that would allow me to do that. He wouldn't let me represent Earl. And he tried to recruit an attorney for Earl. We had a federal judge who contacted over 150 attorneys to represent this guy who was actually got moved into the death house. They wouldn't take the case.
So I want to just back up really quick. You were not an attorney.
No.
How did you know Earl Washington?
I was already on death row, and I went to death row in 1979. Earl came, I think, in 1982. Didn't know where he was at. They put him in the cell. He stayed in the cell for a week. It took me a week to coax him out of the cell. It was my responsibility. I was working with the Virginia Coalition on Jails and Prisons at the time as a client advisor. And when guys came to the row, I had to gather all the information I could because nobody was keeping track of who was on death row, who their attorneys were. So I'd try to find out all this information and get it to them. Then we would try to recruit attorneys. And Earl didn't know who his attorney was. He didn't have any records, didn't know where he was at. And I asked him what he was in for, and he said he didn't know. And I kept asking him questions about the case, and I had a newspaper article that said he had confessed. But the initial confession, he didn't know the color of the victim. He didn't, the police actually drove him in a car, took him to the crime scene. I asked him if he did it. He said no, and I believed him. And at that point, I wound up representing Earl. His direct appeal had been denied. He walked up to me, he had a letter from the Attorney General that said, he couldn't read it, so he handed it to me. And the letter basically said, your direct appeal was denied. If you file your habeas corpus petition within the next 2 weeks, we will agree to a stay of execution. If you don't, we will automatically move for an execution date. Earl couldn't read the letter. We couldn't find an attorney. I had already had the theory of my right to counsel case. I developed it a year before, sent it out to law firms, different law professors, and nobody wanted to touch it. So Marie Deans, who was the head of the Virginia Coalition on Jails and Prisons at that time, said, Joe, you have to file it. So I filed it pro se. And eventually,
You said you were a plaintiff on that case?
I was a straw plaintiff, just so I could do the pleadings and get it in. Once I filed it, I contacted Jack Boger, who was the head of the NAACP Legal Defense Fund at the time. And Jack said, well, he called his old firm, Paul Weiss. He said, the guy's filed the case. We have to back him. So he recruited his old firm to come in and take the case.
So the Gerarratano versus Murray case came after Washington, right?
That was the case. it's to this day it's still Gerarratano versus Washington, and just my name appeared first because when I typed it, that's how it came up, and that's what the court ran with. But it's really all about Earl, and eventually we moved to have it class certified, made it a class action, and added other plaintiffs, other guys that didn't have attorneys.
How many guys ended up joining total?
7 that were named plaintiffs in the case that actually didn't have attorneys at that time, and who I was actually representing. I mean, I had filed for stays of execution. One guy, Savasky Pointer, he had 5 death sentences in 3 different jurisdictions. He had 5 cert petitions that had to go in. He had attorneys for 3 of them. We couldn't get attorneys for the other 2. The first 3 cert petitions were out of time, and the clerk of the Supreme Court said if we could get the other 2 filed in time, that they would consolidate them, let them come in. I had never filed a cert petition. Marie said, you have to do it. And I said, okay, I'll give it a shot. I said, how much time do I have? She said, a week. And I got it done in a week, and all of them went in, and we got him a stay of execution. He was executed years later, but...
When did Eric Friedman and...
Eric got involved with Earl's case. He recruited Paul Weiss to handle the right to counsel case. Nobody wanted to take his habeas corpus. Paul Weiss said, we'll take the right to counsel case, but we're not going to represent Earl on his habeas. It's too much work. And I'm like, he's in the death house. He's going to be executed in 14 days. If they kill him, we don't have a plaintiff. I said, he's our poster child for this case. Here's a guy that can't read or write, and the Attorney General's telling him to file his own habeas corpus petition. How can that violate? Yeah. So I wound up firing Paul Weiss, and Jack talked me into bringing him back, and Eric agreed to take the habeas, and I blessed him for that. That was, and the moral of that story is that Earl was innocent. It took us years to prove it. We got the DNA. He was completely exonerated. It took us 13 years to get him off, 8 years to get him off death row, 13 years to get him out of prison, and another 4 years to get him fully pardoned. And he now lives in Virginia Beach. Once I left prison, Deirdre Enright, who runs the Innocence Project at UVA, asked me if I'd come to work for her. And so I'm working as a paralegal for the Innocence Project, actually handling their backlog of applications of about 800 cases. So what I have to do is I go through the applications, read the records in the case, make recommendations to whether or not to take the case, what needs to be investigated, whether or not they meet the criteria for the Innocence Project. A lot of the guys don't get the difference between legal innocence and actual innocence. And the Innocence Project only deals with actual innocence. There's a big difference between pre-Earl and post-Earl. Once the Supreme Court decision came down, people realized that there was a problem here, and the Supreme Court didn't fix it. With the advent of DNA, there were a lot of exonerations, both capital and non-capital cases, and people, the big firms, started stepping up to the plate. The solo practitioners couldn't do it by themselves. The specimen death cases are too expensive. The big firms have to make money, but they were willing to step up to the plate and take the cases. To this day, there's still no right to counsel, so pro bono counsel is needed. These guys can't afford it. They can't afford the attorneys, and they need good attorneys. In the states that do appoint attorneys, they tend to get guys coming fresh out of law school that don't know what they're doing, and these guys handle the trials as well, and everything with our current court deals with procedure. If you don't follow the right procedures, and the ABA has been educating attorneys.
If there were one sort of message you can get out to attorneys that are considering taking one of these cases, either capital or non-capital, doing pro bono representation? What would you want to say?
Seek out advice from those who have been in the trenches doing it, but more importantly, talk to your clients. Don't assume, as in Earl's case, because there was a confession, that he's guilty. Reinvestigate the case. Just don't take it for granted that somebody's guilty, which is what happened in my case. Even my pro bono counsel originally said, well, he confessed, so he did it. We just have to find mitigation. And in that process, when they had the investigators came back and said, wait a second, are you sure your guy's even guilty? And everybody was shocked. So don't assume, even if there's been a trial, that somebody's guilty. Don't necessarily believe your client either. Not every prisoner is going to tell you that he's innocent. That's the myth. But the ones that do, you have to look at it. And remember that these guys are not educated. A lot of them have been abused. They have problems with authority. But talk to them. Treat them like a human being.
How did you kind of get into the role of advocate when you were in the prison system?
My interest in the law came about, I was using it as a club to beat the system. I was fighting the system with my fists, and that wasn't working. I was getting beat down, chained down to the bed. They had me drugged up. Another prisoner handed me the first edition of the Prisoner's Self-Help Litigation Manual. It's about that thick. He said, you have to fight him this way. And so I initially used the law as a club to beat the system up. But as I started reading the law, I started to respect it. I understood it. And you read some of the old Supreme Court cases from the 1800s, and it's like poetry. These guys are citing philosophers, and so I wanted to read all that stuff. And somehow I understood it and came to respect our Constitution. But even at that point, I wasn't so much an advocate for people. I was going through a lot of stuff myself. I had dropped my appeals. I wanted to be executed. Didn't have any purpose in my life. And Marie found my weak spot. Marie Deans, who ran the Virginia Coalition, she said, I need you to do this. These guys need help. And as I started digging into some of the cases, I realized they did need help, and I had a talent. And I learned from the first case I filed where I was embarrassed in the courtroom. And I said, that's never going to happen again. So I just began reading everything I could get my hands on. I would write law firms. I had questions. Well, let me write these lawyers and just ask them a question, or write this law professor. They like to teach. Let's see what they. And if I'd send out 100 letters and I'd get 60 responses, and they would send me books, they would send me materials, and I just took it on as a challenge. But I learned through that process, dealing with some of the guys, especially the guys on death row. It's a lot of responsibility to, here you are. I'm not a lawyer. I'm learning this stuff out of a book. And if I don't cross this I or dot this I or cross this T right, this guy could be executed. And that was scary. But it made me good at what I do, at what I was doing. And
how did you deal with that fear in those moments?
Compartmentalize it, push it to the side, and what I call acting like a lawyer, being dispassionate and looking at the case and keeping my emotions out of it, except when I was arguing. then it's good to get the emotions back into it. And so my hero there was Clarence Darrow. I started reading everything I could about him. And,
I think you're the hero for many lawyers.
yeah. But then my other heroes were people like Eric Friedman and Dick Burr, who later headed up the prison the NAACP Legal Defense Fund. Al Bronstein with the National Prison Project, Elizabeth Alexander. These were all people that ran the prison project, and we became friends, and they became mentors to me. And some of my first attorneys, after my direct appeal was denied, I asked to be executed. A professor at UVA, Richard Bonney, took an interest in my case and recruited a young attorney fresh out of law school named Lloyd Snook to take my case. I was one of the few people on death row that had a lawyer at that time. And Lloyd was handling like 6 capital cases and fresh out of law school. And the row was growing. We went from 6 people to 38 in a matter of 2 years.
So what were the conditions like, what were the conditions like that kind of drove you to want to drop your appeals? And what were the conditions like?
Well, in my case, it was, Mecklenburg was a supermax prison. It was very abusive. There was a lot of guard on prisoner abuse. We were all drugged up. That was the main control mechanism. Thorazine was, I mean, literally, they would hand you a bottle of Thorazine and tell you to drink all you want.
So when you say drugged up, it was that the prison was giving you drugs
Yes.
to deal with it. It wasn't that the inmates were
No,
getting these.
no. You can go into any prison and get drugs. I mean, they're there. But these were the psychotropic drugs that they give you to, it's easier to deal with you like that, keep you as a zombie. And that never worked well for me. The drugs make me feel stupid, and I would fight against that. But back then, you didn't have a choice. If you refused to take it, they would come in and beat you down, chain you up. And I did that for a year. And they would come in, beat me down, chain me up, strap me to a bed, hit me in the hip, knock me out for 3 days, and I'd get up and do that again. And that's when another guy on the death row handed me the book and said, "You can't fight him this way. You have to do it this way." And he was a former cop. And he was the first execution in Virginia. He was a volunteer.
So did you find once you started helping other guys with their appeals, that motivated you to work with your lawyers and?
Yeah, it did. It motivated me to work with my lawyers, but it was more, I guess I was going through a spiritual crisis, not knowing, I grew up in a crime family. My mother ran one of the largest drug smuggling operations on the East Coast. She was tied in with Carlos later in the Medellin drug cartel. She was my main source of drugs from the time I was 11 until the time I went to prison. And I didn't see any rhyme or reason to my life. I didn't know, who I was. And
How old were you when you were?
21. I began using drugs at age 11. I was injecting morphine or Demerol at 11. And I've said this before, and I've said it a lot, winding up on death row actually saved my life. And it did. But I think that the big turning point for me was being in the death house with an execution date. I actually sat in the electric chair and got up out of it once. I had 5 execution dates. Only 3 of them were serious. 2 of them were serious, 3 of them weren't serious.
Did you know when you were facing a serious one versus?
Yeah. As your appeals start winding down, you know you're getting to that point. And you face your mortality. And sadly, most of the guys, and I tell this story a lot, most of the guys on death row that I was with, and the prison prefers this. They can't tell you who their lawyers are, they can't tell you where their appeals are, but they could tell you everything that happened on every soap opera for the past 15 years. They block out that reality.
You said the prison prefers that.
Yeah, it keeps them docile, it keeps them preoccupied. You're living with your executioners. You're on death row, these are the guards that they're going to come in and chain you up and carry you to the next guard to put you in the chair or lethal injection. So it's hard dealing with that, and you could see these guys didn't want to deal with that reality. Why that didn't happen to me, I don't know. I still haven't figured that out. That didn't work for me. Once I realized, this isn't right. And I've always had this instinct to fight. But sitting there with death right there in front of your face is coming face to face with your own mortality, sort of takes your ego and pushes it down into the floor.
So how do you reconcile those two things? You have you have no ego, it's way down here, but you have this desire to fight, and you have to wake up every day.
But it wasn't a desire to fight for me at first. It was to fight for everybody else. And even now, people tell me to talk about your own case, fight. I can't do it. I still look for the next fight. And even before I left prison, I had filed another case. Again, pro bono counsel came in to help here in D.C., Relman, Dane, and Colfax. A wonderful attorney named Giarratano. It was an ADA case. The law in the ADA has been in effect for like 30 years now, and the Virginia Department of Corrections has never been in compliance with it. They brought a blind guy in, set him on a bed, and said, "Fend for yourself." This guy couldn't get to the chow hall. They wouldn't let him have a cane. He had no kind of training. There were no programs available to him. I filed the case, and we recruited Relman to take the case after it was filed, and we won the case.
Do you have a favorite fight that you can remember? A favorite legal fight?
Murray versus Gerarratano was probably the best one. I mean, that was a game changer for me.
Yeah.
But there have been others. There have been some abuse cases, medical cases. A case now that I'm working on, when I was sent to Supermax in 1998, when I came back to Virginia, Virginia had just built its new Supermax. And there were like 5 guys years ago when we saw the blueprints who said, we're all going to wind up here. One of those guys that went with me in 98 is still there. Still in solitary confinement. Has been there since 1998. And I've been working on a case for him.
Is he somebody that has
He's lost his mind. No. He has nobody. And it's not, he hasn't done anything in 30 years. He's been, but they hold grudges. But he's basically lost his mind now.
How would you describe, or what's your opinion of lawyers, having worked with them in different situations?
I've met a lot of good lawyers, and I've met a lot of not so good lawyers. But to this day, I have lawyers that I consider family, that I call on whenever I need them for something. But I've met a lot of lawyers that just don't care. It's about the money. But the majority of lawyers I've met are good people, and I enjoy working with them. I enjoy challenging them, guilt tripping them every chance I get.
What's probably like your favorite aspect of working on behalf of others, trying to connect them with lawyers? basically kind of being a lawyer yourself, but without the title.
People always ask me if I want to be a lawyer. I said no. I'd rather work as a paralegal. But I enjoy connecting people, and to watch people like Eric, Friedman, or some of the young associates that I've worked with, once they get involved, watch them grow, and become committed to doing the kind of work that they do, and calling them up years later and saying, hey, we need some help, and remind them that but when I go into law schools and talk to students, the first thing I do is, anybody here want to be a prosecutor? After I tell my story, I ask that question, and you'll see them look like, because they think I have a very low opinion of prosecutors. And I have to tell them, I said, no. We need good prosecutors. Prosecutors have a lot of discretion. If you're a good human being, you'll be a good lawyer, whether you're a prosecutor or a defense attorney. So work on being a good human being first, or at least get there. If you have to do the ego thing and become a good lawyer first, remember to become a good human being somewhere along the way.
So I know how you've met Eric, and I know Eric's involvement with the ABA project. Can you kind of describe, were you working with Eric when he started working with the ABA Implementation Project, or?
No, I started working with Eric when he was a partner at Paul Weiss and Rifkin. I don't think he was involved with the ABA project back then. I'm not sure when this project actually formed. I know you became very involved after Gerarratano versus Murray. But Eric isn't the only one. I work with Don Salsman. These lawyers with these big firms helped found a lot of the Innocence Projects. Barry Scheck and Peter Neufeld founded the Innocence Project in New York. That's where it started. Well, there's a debate whether it started in Illinois or New York. You had David Potes in Illinois, who I met when I was in Illinois, but it wasn't the Innocence Project, and it was just law students. And they got some people exonerated, and the Innocence Projects came about after that. But people like Barry Scheck and Peter Neufeld, these were high-profile attorneys that could talk the lingo and get with the big firms and convince them of the need for this.
And have you seen some of the fruits of that with some of the other guys that you've worked with?
Yes. I've actually been working with Don Salsman, who's the pro bono counsel for Skadden, working on 2 cases with him. He's recruited me, the guys that I knew that were in prison. And I've been able to connect some of these people. Okay. Well, the ABA Death Penalty Representation Project is probably, given that there is no right to counsel in death penalty cases, is probably one of the most important aspects of the law that I see now, because this is about our Constitution. It's about who we are as a society. And there is no right to counsel. So this project goes out and gets these attorneys, it finds these attorneys to come in and represent these guys. They're not popular cases. You're going to get beat up. I know firms that won't use their letterheads when they're associated with death penalty cases, but they still come in. They know this is the right thing to do. And this project is the core of that. Without that, I don't think it would happen. You would just have individual lawyers taking on cases. There's no organization that that has a public face that can say, hey, we need to do this. Without it, I think our Constitution would be disrespected, but more than that, people would die. People forget that DNA. I talk to people a lot about DNA. Well, see the system work. DNA exonerated this person, the system worked. No, DNA shows how broken the system is. And I think this project gets that. They realize that we just can't rely on DNA. We have to get in and look at these cases. And without somebody that advocates to take the point on this, there is no other organization in the country that does this. None of the state bars are doing it that I know of. They're not doing it in Virginia. And some of the other states that I've assisted in, they're not doing it there. So it's been this national organization that has taken the point on this. And you know, if I could stand out there and cheerlead, I would. It's needed.
What do you think is the most critical aspect? Why is it so needed?
Well, it's needed because I remember, I go back to Earl Washington's case. Here's a guy that's basically mentally challenged, can't read or write, and you have attorneys for the state, the Attorney General's office coming in and saying, file your own habeas corpus and we'll agree to a stay, and if you don't. These are lawyers. Some of these people are members of the American Bar Association. So we need another voice, and you people are that voice. You remind people like attorney generals, and you're part of our profession. You shouldn't be doing this. And if you do, you'll see us in the courtroom. You're not going to be battling against Earl Washington. You're going to be battling against us. And it's because of that Earl Washington's alive. And not just him, there are 156 other people that are alive because of that, because of the work that you people have done. And I had attorneys, and all my attorneys were pro bono. So it's made a difference, a big difference.